I'm Rachael Griffith. I'm a lawyer in Tyler, Texas. I'm the managing lawyer of Griffith Law Office. We have an office in downtown Tyler. And today I want to talk to you about the basic stages of a family law case. What happens, what to expect, and how your case might progress. Every family law case is civil litigation. It's the same as if you're suing a company or going through collections. It's a civil law case. It follows the Texas Rules of Civil Procedure. So every case starts with a petition. You file a petition in the county where you reside, and you put in the petition your request for relief. That petition has to be served on the other party. And so you will receive, or your attorney will receive, a citation from the clerk's office that will need to be served on the other side so that the court knows everybody is aware of this litigation and has proper service of everything that's pending. That citation can be served on the other side with a process server, or the other person may already know that it's coming and sign a waiver of service. Sometimes people see the word waiver and they really are uncomfortable signing because they don't want to waive any of their rights. But really, typical waiver of service just waives the right to be served. Pay attention to it. It may waive other things. But after the service has been completed, then you may have a temporary order hearing set. Now, what do you do in between filing your petition and your temporary orders being set? That is the time that you will need to use wisely with your attorney to gather documents, get together your income reporting documents, any screenshots, maybe text messages, pictures that are relevant to the issues that are about to be heard. You may want to start gathering bank records, witness statements, things that are relevant for the next hearing that's set in your case. Now, temporary orders hearing, if it's under a temporary restraining order, will usually happen within 2 weeks of the petition being filed. If you have trouble serving the other party, maybe your process server is not able to get in touch with them, get them to answer the door, then you may need to renew and extend that hearing and have it set later, or ask the court for substituted service or alternate service where you serve them by posting the paperwork on their front door. Or maybe you serve them by an alternate source that is a reliable way to communicate with them, email or some other way that you could get the paperwork to them so the court knows they have notice of the proceedings. So at temporary orders, you will either try to settle your case with the other side beforehand, or you'll go in front of the judge and put on your evidence for your requested relief. What do you need for temporary orders purposes? If it's a divorce, maybe you need to make sure all the bills are paid, that each person knows where they're allowed to live, if somebody has exclusive use of the marital home, whether or not you're going to exchange inventories. Maybe you have kid issues that need to be heard, who has custody of the kids, who has possession of them, and whether or not child support is paid. All of that evidence is going up in front of the judge at the temporary orders hearing, and the judge will make a ruling at the end, if you haven't settled, on what's going to happen for the purpose of temporary orders. Typically, temporary orders are in place for at least a few months, 2 to 3 months on the shorter end of things. They can go longer depending on the court's urgency. Then during the temporary orders phase, you're typically conducting discovery. That's that next phase where you are serving formal requests for discovery, where the other side has to produce documents that are relevant to the case at hand within a certain time frame, usually 30 days from the time you serve your requests. You can also have some self-help discovery where you gather records by subpoena, you gather them by public information requests, you ask your bank to gather records with a business records affidavit to authenticate the records that have been provided. And you're wanting to provide all of this information to your attorney, who will eventually provide it to the other side, so that everyone's cards are on the table. We all know what information the other person has. That will increase your likelihood of success at mediation. If everyone is well aware of all of the information the other person might present to the court, well, then you may be more likely to have enough information to settle, or maybe more motivated to settle at mediation. Once you've concluded your discovery process, you'll want to attend a mediation. Most counties, it's a requirement before you're allowed to have a final trial that's contested in front of a judge. You're supposed to try to mediate the case before you go to court for a final hearing. So mediations typically last at least a half of a day, a morning or an afternoon. Most of them probably a full day. You think, what in the world could we possibly talk about for 4 hours or for 8 hours? You'd be surprised. It takes a long time to get each person's perspective, offers on the table, and process everything that needs to be processed before you can negotiate and get down to the nitty-gritty of what are actually the contested issues and can we solve them at mediation. If your case does settle at mediation, it's not entirely over yet. You'll leave with a mediated settlement agreement that's signed by all parties, but it's not signed by the judge. So that mediated settlement agreement needs to get turned into a court order. That's a matter of paperwork, making sure the attorneys get things drafted and circulated. Everybody agrees that what was agreed upon at mediation has ended up in the mediated settlement agreement. If you don't settle at mediation or by any other informal process of settlement, then you will go to a final trial. Sometimes that's a jury trial. Sometimes that's a trial in front of a judge, a bench trial. Just depends on how you've strategized that with your attorney and what you've requested of the court. So when you get ready for trial, you're going to be making sure your evidence is in order, the discovery is completed, and that all the witnesses know to be there. Sometimes you need to subpoena the witnesses to be there, and you have your final hearing. Sometimes you get to your final hearing and the judge resets it. You need to make sure the court is aware of the amount of time you really can anticipate to hear the final hearing. If it's a custody case, it can be anywhere from a few hours to a few days. Divorces with property and kid issues can be even longer. It takes a while to get all the evidence out in front of the judge in the form that the judge needs to see it to make sure it's admissible. And it's not as simple as going and announcing what you want and having a few witnesses. It can take some time to get that evidence in front of the judge. Once the final hearing is done, the judge will make a ruling, and then the orders will be circulated that will match the ruling. Just because you've had a final hearing doesn't mean that it's over. Sometimes people will file an appeal. If there's an issue or an error in the law that your judge abused discretion in their ruling, the party that's upset about the ruling may file an appeal. If your case goes up for appeal and the appeals court accepts your case, reviews it, and decides there was an error in the law, it can be remanded back down to the trial court to do it all over again. So that's another benefit of mediation. If you settle at mediation, there's no appealing it. But just because you've had a final hearing does not mean that your case is entirely concluded. Of course, talk to your attorney along the way, and they will be telling you what to expect and possible outcomes and next steps for each step of the process of your